Hello guys, so I'm back with the rest of the sections that was left to cover, and we start with section 5. The previous video was a bit longer. I didn't have track of that. After I finished it, I saw that it's 40 minutes. So I'll try to keep this video or audio a bit shorter as much as I can. Okay, so let's proceed. Revocation of proposal and acceptance. A proposal may be revoked at any time before communication of its acceptance is complete as against the proposer, but not afterwards. That is, when you are suing against the proposer or suing the person who proposed you to say do something to see uh, in my example to invest the money. So when I'm suing that person, say for specific performance of contract or for non-performance or anything, then I can put up the defense that the proposal was not revoked, uh, that it because it never reached me that I'm the acceptor. I couldn't see it. Where is the letter? It might have got lost in the uh, post or something like that. So it was not communicated properly. As against an acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor, but not afterwards. So acceptance can also be revoked. So say I'm accepting the thing by a letter, so I can revoke my acceptance of the say proposal. So that is also before the communication, that is before my letter of acceptance reaches the proposer. I have to revoke it. But once he has got the letter, read it, and acknowledged it, I cannot revoke it afterwards. It will be impossible. I can be sued. He can sue me. So let's read some illustrations. A proposes by a letter sent by post to sell his house to B. B accepts the proposal by letter sent by post. A may revoke his proposal at any time before or at the moment when B posts his letter of acceptance, but not afterwards. B may revoke his acceptance at any time before or at the moment when the letter communicating it reaches A, but not afterwards. At the moment also he can do it, or before also he can do it. So say he dispatches the thing uh, simultaneously, say 2-3 days later, or say 2-3 hours later even. So the post reaches at the moment, that is together the letter of acceptance and the letter of revocation of the acceptance, or the letter of proposal, letter of the revocation of the proposal reaches together. So that also is okay. That also revocation will be said to be complete. We cannot sue the other person revoking it for specific performance of contract. But if somehow the letter reaches afterwards, letter of revocation reaches after the proposal letter is read, or the acceptance letter is read by the other party, the acceptor and the proposer, vice versa. So then after that, simultaneously, sorry, what am I saying? So then it cannot be revoked. Oh, I just woke up from the nap and I'm all groggy. So revocation where an offer gives the offerer an option to accept within a fixed time, it may be withdrawn even before the expiry of that period, unless there is some consideration keeping it open. So when the offer so the offer itself carries a condition that within 3 days you have to accept the offer, or within 1 week you have to accept the offer. So that's a fixed period. So it can be withdrawn at any time. The offer can be withdrawn at any time before, say, the 3 days or the 7 days time. It can be withdrawn. But if some consideration has been given on my part or someone else to keep the offer open for say the period, the whole of the period, and not get it, withdrawn, then it has to be kept open. Otherwise, it can be withdrawn at any moment by the proposer before the fixed time given. So this has been held in Alfred Sklonak versus Muthurena Chetty, 1892. Okay, then we move on to section 6, revocation how made. So how will you revoke it? So this is procedural part in contract. The substantive part we read, so the procedural part, let's see. A proposal is revoked by communication of notice of revocation by the proposer to the other party. A notice is given, that means a letter or a phone call, any kind of notice. Notice like that, not a formal notice that we give a legal notice or something like that, not like that. By the lapse of the time prescribed in such proposal for its acceptance. So the acceptance that has to be given, so I'm not giving the acceptance within 3 days or within 7 days, so then also the proposal will get revoked because I didn't do it within 3 days or 2 days that was given, so it automatically gets revoked. Or it can be revoked by any letter, phone call, or anything. If no time is so prescribed by the lapse of a reasonable time without communication of the acceptance. So if nothing is prescribed, so without communication of a reasonable time, then if no fixed period is given, then a reasonable time, say 7 days or 5 days, like that. After that, it will get revoked automatically. By third is by the failure of the acceptor to fulfill a condition precedent to its acceptance. So say the proposal has asked the acceptor to expressly come to the office or come to a certain place and then make the acceptance, or to dial a certain number and then make the acceptance. So if that is not done, say I'm not doing that, instead of that I'm doing it in some other way, say I'm sending a letter, or I'm not going to the office and doing it but just by call, then it's not a proper acceptance, right? You are not going by the rules of the proposal. And acceptance has to be unconditional. If it's not so, then there is no contract. Then 4, by the death or insanity of the proposer. If the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. So an offer is also a proposal or offer, whatever you say, also gets revoked by the death or insanity if the proposer himself dies or goes mad. Then how will how will he perform his part of the contract? So it should get revoked, right? If the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. So it has to come to the knowledge of the acceptor before he accepts. Once he accepts, it becomes binding, then his legal heirs might be drawn into the suit to fulfill the part of the promise. If he goes insane, or the money, if some consideration is given, the money can be recovered from his property by attachment. So there are ways to execute the contract if the court of law wishes to do it. So that's that. Then we move on to section 7. Acceptance must be absolute. So that is what I'm seeing from the preliminary part only, that acceptance, there should be no conditions in acceptance. There can be thousands of conditions in the proposal, but if you accept it, it has to be unconditional. In order to convert a proposal into a promise, the acceptance must be absolute, unqualified, be expressed in some usual and reasonable manner unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it is to be accepted and the acceptance is not made in that manner, the proposer may, within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in the prescribed manner only and not otherwise. But if he fails to do so, he accepts the acceptance. So here it is, It's very literal. It has to be, acceptance must be expressed. It has always have to be expressed, that we read in the previous sections, that it can be dispensed with the notice of acceptance if the proposer wishes to, but otherwise if nothing is stated, then it has to be accepted in a formal, the acceptance has to be communicated in a formal manner, usual and reasonable, that is by a notice, and properly, so that it reaches the ears of the proposer only and not some other person. And unless the proposal prescribes the manner, if it proposes the manner, proposal says the manner that yeah, it has to be done through by a letter, then you cannot do it by phone, you have to do it by a letter. And if nothing is said, then you cannot do it, you can do it by phone, because nobody sends letter these days. So if the proposal prescribes a manner of acceptance, then it has to be done in that manner only, and also within a reasonable time. So the proposer, after getting the acceptance, say he got the acceptance and he sees that oh, I told this person to accept by a letter, he has telephoned me and accepted it, so he can now revoke it. And if he does not revokes it, if he says, oh, that's okay, he called, he didn't send me letter, he called, that is a easier thing to do, I'm okay with it, then he accepts. If he does not revoke it, then that means he accepts it, the changed condition. So then it becomes pending. So we have some comments here. Acceptance must be unqualified and without condition. The cardinal principle in the light of section 7 of the act is that the offer and acceptance of an offer must be absolute without giving any room of doubt. So there should not be any shadow of doubt, like whether you are not don't want to accept it or accept it, it should be completely without any doubt. It is well, and but if the proposer thinks that no, it is not in the format that I wanted it to be, or the criteria do not match, or something is wrong here, so he can revoke it. Or if he doesn't, that means he accepts it. So it's up to him, the propose it up to the proposer. So that's that. It is well settled that the offer and acceptance must be based or founded on three components: certainly, commitment, and communication. So commitment must be there, that is commitment of the acceptor to perform his part of the contract, and also commitment of the proposer to do his part of the contract. Otherwise, specific performance of contract can be suit can be brought on that. And communication is also very important. Proper person and proper time must be communicated. If any one of the three components is and certainty, another is, that is the clarity, that yeah, I'm doing this has been stated, this has been asked of you, and this has been fulfilled. So everything that is asked, everything that is fulfilled, everything matches, and yeah, it happens, the contract happens, and we can proceed with it, legally enforceable one. So these three things must be there. If any one of the three is lacking, either in offer or in acceptance, there cannot be a valid contract. That is Kilburn Engineering Limited versus Oil and Natural Gas Corporation Limited, EIR 2000. In this case, this has been held. These are all landmark cases. That's why they have been stated in the Baird Act. Otherwise, they wouldn't be. They fulfill the gaps of the enactment, or something, the enactment that does not talks expressly. So these are talked about in these precedents that we should absolutely follow and keep in mind, along with the provisions of the enactment. So next we move on to when the acceptor puts in a new condition while accepting. The contract already signed by the proposer is not complete until the proposer accepted the condition. So the acceptor might put in new conditions. Yeah, it is acceptance must be unqualified. Acceptance must be absolute and unqualified, but the acceptor can put conditions. So then it becomes voidable, the contract. The proposer might accept the rules and say, yeah, it's okay, let's do the contract in this way, your way only. or he might reject it. That no, of course not. We can't do it in this way. So this has been held in Kilburn in so this has been held in Haridwar Singh versus Begum Sumbrui, AIN 1972. So as we say, law is not rigid. It's actually flexible and it changes with the wants of the society, societal norms, and it is actually a beneficiary. It actually wants to benefits the community or benefits the individual. That's why law is made. So for that purpose, it keeps evolving. Like here, first, if it was rigid, we could have said that no, acceptance has to be absolute and unqualified. Otherwise, the contract fails completely. End of story. But no, here many exceptions or evolved rules and precedents are laid down that if this does not happen in this manner or that manner, it could be done. Okay, next. An acceptance with a variation is no acceptance. It is simply a counter proposal, yes, which must be accepted by the original proposer promisor before a contract is made. So an acceptance which is varied, like we said in the just before in Haridwar Singh case, an acceptance with the variation, it is no acceptance. It's simply a counter proposal. So this counter proposal has to be accepted by the original promisor or the original proposer, and then only the contract can be made or a new contract is made, that instead of the old one. So this has been held in Haji Muhammad Haji Jiva versus East Penna, 1900, Bombay case. And then implied acceptance. So acceptance always doesn't have to be active, like we read before again, that again gives the implication of the law not being rigid and being a bit flexible to include the benefit of everyone and benefit of the individual. Actually, it's a beneficial. Every enactment is made keeping in mind the benefit of the society or benefit of the individual. So it's not always made rigid. So what do we see in implied acceptance? The acceptance of a promise can be in express terms and can be in implied terms. Conduct of the parties showed that plaintiff had impliedly accepted offer and received part of the amount. So acceptance of the promise, it can be implied also. Say I have uh, asked that whoever wants to float a tender and said that whoever accepts my offer, or say not floated a tender, let's not put it like that. Say I have given an said to the next person that if you want to um construct something in my estate, then you have to by next 2 days you have to deposit say 10,000 in my account, or 10,000 it's like a very weird amount. I said 30% of the 30% of some amount, say I say a total price of something in my, or 10% of some amount in my uh, account. So I'm not asking for anything else. So he can, the opposite person can give me a notice, say by letter, or he can call me and say, yeah, I accept your offer, I accept it, and that I made it to one person only, not tender. This different example. I made it to one person only, and he doesn't. He can also call me, and he's not calling me, or he's not communicating with me in any manner. Instead of that, what he does, he goes and deposits the percentage that I wanted him to do, and in the manner I wanted him to do, say in draft or in check or in cash, whatever it is, whichever account I said, whichever manner I said, everything, he does that, takes the receipt, and he sends me the receipt instead of any uh, express communication of the proposal. So then also he has accepted it. It's implied acceptance because he has given the consideration that was required. So this has been held in Rakesh Kumar Dinesh Kumar versus UG Hotels and Resorts Limited, AIR 2006, Himachal Pradesh case. So another, next we move on to no second acceptance. The rule of law is that mere offer to sell property which can be withdrawn at any time and which is made dependent on the acceptance of the person to whom it is made is a mere nudum pactum. The person to whom the offer has been made cannot by acceptance make a binding contract after he knows that the person who has made the offer has sold the properties of someone else. Okay, so this is I think it's a British case law, yeah, very long time ago. So if you have sold the property already to someone else, then firstly, then after that, when you are making the offer to sell the property to someone else, then how could it be? I mean, the acceptance doesn't make any binding contract because you've already sold the thing. The main part of the property, the main foundation of the contract, or the thing that, or the consideration, or not consideration, the subject of the contract, it is already gone, already sold to some other person. Then how can you sell it again to someone else? That has been held in Dickinson versus Dodds 1876 case. Okay, so we move on to section 8, acceptance by performing conditions or receiving consideration. Performance of the condition of a proposal or the acceptance of any consideration for a reciprocal promise which may be offered with the proposal is an acceptance of the proposal. So that what I just implied, what example I just placed in implied acceptance, that the person to whom the offer has been, the proposal has been made, he doesn't give a notice of acceptance, he doesn't call or sends any letter, he just goes and deposits the consideration or does everything that I asked him to do, and doesn't tell me that yeah, I accepted it openly. So then also it will be, that is what is written in section 8. Performance of the conditions of the proposal, whatever conditions has been given, that has been complied with, or the acceptance of any consideration, or consideration has been given from that part, from the promisee to the promiser. So that has been given for a reciprocal promise. Say for the reciprocal promise, say I, that old example you take. So the reciprocal promises, I'll give 10% of my income. So consideration is the 20% of my money and the stocks. So that has been given, which may be offered with the proposal. That is also acceptance of the proposal. I don't have to call or give notice for that. Implied. That is also implied, section 8. Okay, so what are comments? What is given in the comments? Performance by act in interference of acceptance. The defendant company advertised. So this is a case law again. Oh, Carlyle versus Carbolic Smoke Ball Company. Yeah, I was blabbering about it in the previous video. Let's see if I have said it properly. They have given the facts here. The defendant company advertised that they would pay pound 1000 to any person who used their carbolic smoke ball for a certain time, any yet contracted influenza. So if somebody, they just advertise that if somebody uses our smoke ball and contracts influenza, then we'll give them 1000 pounds. It's so good. They had so much confidence on their smoke ball, the pharmaceutical company. The plaintiff purchased the medicine, that is Mr. Carlyle, used it for the stated time but contracted the disease. Oh, it was held that the contract was accepted by being acted upon. So here he does not give any express notice of acceptance, but he did what was asked of him. So he accepted it by acting upon it. And the defendant now has to give the price or the money. He was allowed to recover it. 1893 case. Carlyle versus Carbolic Smoke Ball Company. Okay, next we move on to section 9 and the last in this chapter. Promises, express and implied. So promises, yeah. So now, just now we read that acceptance can be expressed or implied. And now promises. So what is a promise? When offer is made and it is accepted, and the it is acceptance is complete, then only the promise sets in. Each set of offer and acceptance makes a promise. So, insofar as the proposal or acceptance of any promise is made in words, the promise is said to be expressed. Insofar as the proposal or acceptance is made otherwise than in words, the promise is said to be implied. So, if the proposal is also made by letter or phone call, or by expressly by words, then promise will also be direct, express. But if proposal cannot be acceptance made implied, like fulfilling the conditions, then promise will also be implied. So let's read the comments here. Implied terms. A contract can be implied, and it is very clear from section 9 of the Contract Act, but it is a fundamental principle of law that the court should not make a contract for the parties. A contract implied, in fact, requires the meeting of minds. Yes. The court should refuse to read an implied term into a contract which is silent on the point or did not clearly indicate the nature of the term. However, when the stipulations are clear and in contemplation of the parties, or which necessarily arise out of contract between the parties, they will be implied. State of Maharashtra versus Saifuddin Muzaffar Ali Saifi. So, 1994 case. So, that it's stated here that when the contract is implied, when the promise is implied, then much analysis is left to the court to be done. Whether the proposal has been properly made, whether the acceptance has been properly made. And after doing that in a proper way and seeing that there is a meeting of minds, proper meeting of minds of both the parties, then only the court will come to the point that, yeah, there is a binding promise which is implied. So that will give rise to a contract. Otherwise, it will be just another unenforceable agreement, not binding in the eyes of law. That is what is held here. Okay, so I'm finishing chapter 1. I'm not moving on to chapter 2 because the videos are already very long. And do like and subscribe and comment if possible. And stay tuned and do tell me what to do next. I mean, this I said in the previous videos only that I'll do chapter 1, so I did it. And if you want to see more of study vlogs, and not vlogs, it's like audio, more of study content, then do let me know in the comments. And if you want me to do something else, like review something, or do something creative, or sing, or I can't dance by the way, or do read out stories or anything like that, then do let me know. And I'll be doing it if I can do it, of course, if it's within my capacity to do it. That is totally true. So bye for now. Ciao.